Hi, I'm Jim Covington. Today is August 16th, and I'd like to welcome you to this week's issue of ISBA Statehouse Review. I have 6 bills we'd like to talk to you about that have been enacted into law by the signature of Governor Quinn, and tomorrow the General Assembly will be meeting in Springfield to discuss pension reform. The first bill I'd like to talk to you about is Public Act 97-953, introduced by Representative Emily McCasey from Lockport and Senator Jackie Collins from Chicago. It creates the Radon Resistant Construction Act. This will take effect June 1 of 2013, so there's a year build-up time to allow people to adjust to it, and I believe that there's going to be some administrative rules through a state agency to help implement it. But what it does, it requires all new residential construction include, quote, passive radon resistant construction, close quote. New residential construction is original construction of a single family home or dwelling containing 2 or few apartments, condominiums, or townhouses. I could not translate into plain English exactly what passive radon resistant construction means. The definition of the statute is that it includes an installed pipe that relies solely on the convective flow of air upward for soil gas depressurization and may consist of multiple pipes routed through the conditioned space from below the foundation to the roof above. I have no idea what that means, but hopefully that the people in the business will know what that means. The second act is Public Act 97-966. It amends the Mechanics Lien Act. It was introduced by Representative Mike Tryon from Crystal Lake and Senator Pam Altoff from Crystal Lake as well. It requires work to be done or materials furnished within 3 years for residential property and 5 years for any other kind of property. This act sunsets, which means poof, goes away on January 1, 2016, and then the limitation in the Mechanics Lien Act reverts back to 3 years for all property, and that's effective January 1 of 2013. I believe the impetus behind that bill was the lag time in getting a lot of this commercial construction done. The next 2 bills I'd like to talk to you about amend the Trust and Trustees Act. The first one is Public Act 97-921. Representative Emily McCasey from Lockport and Senator Senator Kirk Dillard from Hinsdale were the sponsors. It is an effort by the ISBA Trust and Estates Section Council to modernize Illinois trust law, and this one allows the decanting of trust, and it allows an irrevocable trust to evolve to meet a family's changing needs without court involvement. It is modeled after the laws of Delaware and New York, and it takes effect on January 1, 2013. There is a May Bar Journal article in our Bar Journal which summarizes these in excellent fashion. This and the second bill, which is Public Act 97-921, and that allows for the use of directed trust. That's also sponsored by Representative Emily McCasey from Lockport and Senator Ira Silverstein from Chicago, and it allows additional flexibility to Illinois estate planning and administration of trusts by the use of these directed trusts. Directed trusts allow a settlor to establish a trust and separate the administrative authority between a trustee and another person or entity acting as a fiduciary, such as an investment advisor. It is modeled after Delaware law as well, and more than 30 states allow for directed trust in some form. That will take effect on January 1, 2013 as well. The next bill amends the order protection laws, and it's Public Act 97-919, introduced by Representative Emily McCasey from Lockport and Senator John Mulrow from Chicago. It makes it a Class 4 felony to violate an order of protection if the defendant had been convicted in another state of domestic battery or certain crimes of violence, or been subject to an out-of-state order of protection. I think that's already the law, that if you have a second violation of order of protection and you have these things from Illinois law, a prior conviction. So I think they were trying to harmonize to pick up the out-of-state convictions. It also makes the actions of a defendant who directed the actions of a third party to violate this section accountable as if those actions had been personally done by the defendant without regard to the mental state of the third party. That takes effect on August 10, 2012. The sixth and final bill is Public Act 97-941, introduced by Senator John Mulrow from Chicago and Representative Cynthia Soto from Chicago. And it does two things affecting dissipation claims in family law cases and child support. On the dissipation claims, it creates a procedure that you've got to follow to allege that the other party dissipated claims. You've got to give notice, no later than 60 days before trial or 30 days before discovery closes, whichever is later. You've got to identify the period when this occurred. It says that no dissipation may be considered if it has occurred 5 years before the filing of the petition for dissolution of marriage or 3 years after the party claiming dissipation knew or should have known of the dissipation. The other thing it does in the child support area, it specifically grants the court the right to order one or both parties to make reasonable payments for health needs not covered by insurance, child care, education, and extracurricular activities, in addition to the statutory child support formulas. This was designed to pick up the case law and does not intend to change the case law, is to make it clear what the judge may or may not order in terms of in addition to statutory child support. And we will see you next week. Thank you.